Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. This is to update you regarding developments in the federal civil lawsuit styled as Steve Goncalves et al. Versus Washington State University, which is currently proceeding in the Western District of Washington before the Honorable Kimberly K. Evanson, District Court Judge. On the 27th of February, as we had anticipated, the defendant filed their reply on motion to transfer venue. Now, just by way of background, briefings on a filing, such as a motion, which is an application for a court order, is consistent of 3 court filings. The first is the moving paper, motion to transfer venue, was filed by Washington State University back on January 30th, 2026. Second item is the response. There was a response in opposition that the plaintiffs filed. They do not want this case moved out of the Western District of Washington and gave their reasons why. Third item in the briefings, reply, which was filed yesterday by WSU, replying to the response. If you would like to see this 6-page document, it is on our sister YouTube channel community page. I've provided a link in the description to this podcast episode. They set out their argument, page number 1 WSU, by saying the ultimate inquiry on a motion to transfer venue is the convenience of the parties and witnesses and interests of justice. Then they allege, here, the Eastern District of Washington is convenient for the parties and witnesses. Moreover, as plaintiffs admit, it is the place where the alleged acts and omissions occurred. And now citing to docket number 17 at 8, which is the response in opposition to change of venue. WSU continues, this is page 1 of the reply, and there is recognized interest in having local communities decide at home. Going into page number 2, they start setting forth a reply to each of the areas that the plaintiffs raised, including sovereign immunity. That is the first argument that's addressed here. Plaintiffs could have asserted only its federal claim and filed in the Eastern District of Washington. Thus, this action could have been brought in the Eastern District. Ultimately, plaintiffs chose to file in state court. They did not choose the Western District of Washington and cannot now claim that they did to reap the benefit of having done so. Convenience factors is the next, and they say here, plaintiffs allege that litigating this case in the Western District instead of the Eastern District would, quote, give the families some protect from intense media coverage. Again, citing to docket entry 17, now at 7. Washington State University has no interest in publicizing these events or this litigation. The same does not appear true for plaintiffs or their counsel, who have not only participated in the media coverage, including speaking in documentaries, but whose counsel has issued a press release surrounding the filing of this lawsuit that can now be found on their website. And there's a footnote here linking to that website publication, which is entitled News Lawsuit Filed by Idaho Unaliving Victims' Family Seeks Accountability from Washington State University. WSU says it would seem disingenuous to court media attention and then attempt to use the same as a reason not to move this litigation back to the place from which it stems. Next, parties' contact with the forum. While one of the plaintiffs resides in the Western District, 4 do not reside in Washington at all. WSU, the sole defendant in this case, is primarily housed in the Eastern District. WSU operates its main campus in Pullman. The acts and omissions taken by WSU staff challenged in this lawsuit took place in Pullman, Washington, in the Eastern District. Those same staff primarily reside in Pullman, Washington. Plaintiff cannot, now going on to page 3, deny this reality by attempting to assert that the party they sued is not school, but the state, and therefore it is housed in the Western District. Never mind the plaintiffs are willing to go further and assert without support that the state of Washington itself is not located in the Eastern District of Washington. This statement, of course, is simply false, because WSU is the sole defendant in this lawsuit and is primarily located in the Eastern District. Its records are also in the Eastern District, as are many of the individuals with personal knowledge of these events. Accordingly, WSU's contacts with the desired form supports transferring this case to the Eastern District. WSU continues, and again, this is page 3 of the reply brief. Plaintiff argues that the location of witnesses outside the Eastern District supports leaving this action in the Western District. However, the majority of Washington-based witnesses reside in the Eastern District. According to plaintiff's own numbers, of the 69 witnesses identified by plaintiffs in their tort claim, 31 reside in the Eastern District of Washington, while only 14 live in the Western District. This factor supports transferring venue to the Eastern District, as more than twice as many witnesses reside there than the Western District. All out-of-state witnesses will either have to travel or appear by remote means. Accordingly, the existence of out-of-state witnesses does not support keeping this case in the Western District over the Eastern District. The next item is cost of litigation. Plaintiffs argue without support that changing venue would increase the cost of this litigation, suggesting that travel costs for out-of-state witnesses flying to Seattle versus Spokane would likely be less. This unsupported statement should be disregarded. There is no evidence that the cost of this litigation would increase there because of a transfer to the Eastern District. Then they go into addressing the next item on page number 4, impartial jury. The interests of justice support transferring this case to the Eastern District to allow the local community where the events occurred to judge these facts. Plaintiffs argue that media saturation and WSU's presence in the Eastern District would cause difficulty in seating an impartial jury in this case. In doing so, plaintiffs speculate wildly about the impact of these events on the local population. The process of voir dire is designed to find and select an impartial jury, and WSU has faith that counsel for both sides can execute on doing so efficiently. The residents of the Eastern District should not be excluded from the process of finding justice in this case because of the possibility that they might have more exposure to these nationally publicized events than people elsewhere. Similarly, the residents of the Eastern District should not be excluded from the opportunity to find justice in this case because WSU is situated there and is an employer of people in the community. Again, the process of voir dire will allow the parties to seek and remove individuals who might have bias and preconceived opinions about this case or the parties. With WSU concluding page 5, the interest of justice and convenience of the parties support transfer to the Eastern District of Washington. All acts in the complaint occurred in the Eastern District, and the vast majority of witnesses reside in the Eastern District. Defendant WSU respectfully requests this court grant this motion to transfer venue to the Eastern District of Washington, dated the 27th day of February 2026. Jordan Jones, Assistant Attorneys General for Washington State University. We now await a ruling, a possible oral argument, a hearing, which the plaintiffs requested. Until next time, this is Kathy. Thank you for joining us here today.